The Federal High Court, Abuja, has adjourned to 18th January 2022 the continuation of the trial of the proscribed leader of the indigenous people of Biafra Nnamdi Kanu. His counsel, Ifeanyi Ejifor, has expressed concern over the constant disobedience of court orders by the DSS. Judiciary Correspondent Celestina iria takes a look at all that has transpired since Mr. Kanu's first appearance in court after he was rearrested and the position of his trial.
Self-acclaimed leader of the proscribed secessionists.
It was the Attorney General of the Federation, alongside the Inspector General of Police,
is the main challenge ahead of all of us,
who on the 29th of June announced the rearrest of self-acclaimed leader of the indigenous people of Biafra Nnamdi Kanu by operatives of the Nigerian Security Intelligence.
Nnamdi has indeed been arraigned and charged before a court of law. What we are doing here today is a public interest aspect of it. Nigerians are entitled to know the factual situation as it relates to associated charges filed before the court of law.
In his first appearance after jumping bail, Mr. Kanu was hooded in black and eventually smuggled out of the court by DSS through the exit used by judges. This was after Justice Binta Anyango had granted the application of the DSS for Mr. Kanu to be remanded in their custody. At the subsequent sitting, despite Mr. Kanu's absence from court, drama ensued between lawyers, journalists, and the security operatives. It was a dramatic and hellish experience on the 27th of July for lawyers and journalists who had come to monitor proceedings of the Nnamdi Kanu trial at the Federal High Court, Abuja. Lawyers, litigants, and journalists were subjected to different forms of security checks before they could gain access into the court. Only selected journalists were allowed into the premises of the court, with operatives of the DSS claiming they were under strict instructions to restrict the number of journalists allowed to report the court proceedings. After prolonged persuasion, a few lawyers and journalists finally gained access into the courtroom. As the matter came up during the court's annual vacation, Justice Anyango adjourned to 21st October because she was not a vacation judge and no fiat was issued by the chief judge of the court to enable her to preside over the case. The defendant was absent from court, but the DSS said they could not bring him due to logistic reasons. Some judiciary correspondents who were unable to cover the proceedings due to tight security protocol of the DSS and those who eventually did cover the proceedings of that day shared their experiences on what transpired. While some believe there are better ways for security operatives to engage with journalists, others believe the peculiarity of the case brought about the actions of the operatives.
Officials who are in charge, the DSS Director General, should call his men to order. They should not harass journalists for a matter as important as that of Nnamdi Kanu and the federal government. It's a matter of global attention where journalists should be allowed unfettered access to cover the proceedings so that people can have a clear picture of what is happening inside the court.
Transpired that there was crass display of arrogance on the part of DSS. Journalists were on duty, carrying out their duty as enshrined in the Constitution, Section 22 to be specific. Now, in the line of duty, we were being gagged by DSS, forgetting that the courtroom and the Temple of Justice is not DSS office. It was, we were completely, embarrassed that day.
The courtroom is not as, large enough to contain all the journalists and maybe people that came in solidarity for Nnamdi Kanu. And in view of the COVID-19, post-COVID-19 era, everybody is trying to be careful. So I think the state wanted a situation whereby, streamline the number of journalists that will come in, as well as maybe 5 or 6 family members. That was the way they put it.
Anxiety that matter has generated. So one will not totally agree that journalists were harassed, but they were trying to control the crowd into the court premises so that criminals will not mingle with the crowd and cause something that can lead to death or anything that is not good.
On 21st October, Mr. Kanu had pleaded not guilty to a 7-count amended charge of alleged treasonable felony and terrorism. The court ordered that he be remanded in the custody of the DSS. At the next adjourned date, being 10th November, counsel to Nnamdi Kanu staged a walkout from the court over refusal of operatives of the Department of State Services to allow some of them gain access into the courtroom. When Mr. Kanu was brought to court, he confronted the operatives of the DSS about it.
I'm asking you, who is stopping them from coming in? I have a right.
The walkout staged by the counsel did not sit right with the judge. She subsequently adjourned the trial to 19th January 2022. Not pleased with the adjournment, without granting them fair hearing, counsel to Mr. Kanu filed an application for abridgment of time. On 2nd December, the court abridged the time to 18th January 2022, a day before the initial adjourned date. This, Justice Binta said, is the only visible day because there are dockets of cases before her and the court will be proceeding on its annual vacation.
Every sense of sincerity.
Counsel to Mr. Kanu tells us how his client has been holding up since his last appearance in court and the recent development of the case.
Because if he complained to us that he's being starved, he's being exposed or subjected to torture and all forms of other treatment that being meted to him, then we are under compelling obligation to interrogate the authority, interface with them and confirm why that is being done. And it's more so when there are pronouncements by the courts, that specific pronouncement by the court and last urgent date, making this an order that he should be changed, his room should be changed from where he is to a more comfortable place. Then, and also, be served a meal of his choice, and also allowed to practice religion, and also allowed to access to his independent medical doctor. And the others the court met in court on that day. They were in court when the other met. At some point, I was like, I even applied to court, allow me and the defense counsel, who was then, who counsel for the prosecution, that's Labaran, to, on the order of court, to visit him, to go and see where he is being detained.
On 14th October 2015, Nnamdi Kanu was arraigned by the federal government on allegations of terrorism, treasonable felony, and money laundering. On 28 March 2018, his bail was revoked by Justice Binta Inyanku of the Federal High Court, Abuja. Celestina, Iria, TVC News, Abuja.